Third fundamental point, it's not good enough for India to say, well, you called him an Indian spy. You referred to the passport that he had in his possession for your internal investigations as establishing that he'd been sent by India. You convicted him of espionage, obviously, as a spy sent by India, and therefore you can't say that we needed to furnish you with evidence as to his nationality. That simply is unsustainable because, as this court made clear in the Avena case, a state that wishes to avail itself and provide its national with diplomatic protection has the obligation to furnish evidence of nationality, commonly by means of passport, birth certificate, as we saw in the Avena case, where the court upheld the United States of America's objection on the basis that Mexico had failed to identify and positively establish the nationality of one of the individuals in respect of whom it was demanding diplomatic protection. And lest it be said by India that Pakistan has somehow represented in a clear and unequivocal manner to India that it's not going to bother with evidence of nationality, that's simply not the case. There's no proposition of law advanced before this court with reference to any authority, the Temple of Bihar case, for example, to suggest that there is the doctrine of estoppel at large. There's nothing. The memorial and the reply of India are shamelessly devoid of substantive legal content. If India wants to argue estoppel, it's too late, but I'll make the argument for them, shall I? There is no clear and unequivocal representation made directly to India with the intention or effect that India detrimentally relies upon it, such as to constitute a waiver of the requirement for India to establish the Indian nationality of Commander Jadhav. State practice. The proposition I advanced, the proposition that none of the 177 states party to the Vienna Convention on Consular Relations disagrees with, because if they did, the others, because there are two here, they had ample opportunity, pursuant to the invitation of this court, to present themselves and take issue with the proposition that I seek to advance. But they don't, because this is an issue which states have refrained from becoming visible upon and adopted a position that I described as being one of studied ambiguity, with the consequence that it cannot be said that there is a general practice accepted as law, opinio juris, by states to provide consular access in cases where espionage was reasonably suspected, such as to evidence that any such practice was undertaken with a sense of legal right or obligation, which I respectfully observe is the essential requirement for a customary international law principle to have crystallized and to be evident. The ILC draft conclusion 9, with the rapporteur, Sir Michael Wood, provides us with ample understanding in this regard. And it's the state practice position as at 1963 that we're concerned with. And we know, I wasn't alive at that juncture, but we know that at this point in time, the world was troubled, sadly, as it seems to be now. All the more reason for the rule of law to be upheld, because those who were participating in this exercise to ensure that a convention could be adopted were describing the task in 1963 as thankless, because distrust and suspicion reigned everywhere, and almost all states had recourse to emergency laws and regulations. Two pivotal figures in international law, certainly for somebody like myself, I can't speak for India, and I daren't try to speak for India in its present incarnation. Sir Gerald Fitzmaurice, former UK Foreign Commonwealth legal officer advisor and then a judge of this court, had observed that national security would be the only reason with sufficient weight to justify restricting communications between foreign nationals and their consular officials. Grigory Tunkin, then head of the legal department of the USSR Foreign Ministry, in the negotiation process, as can be seen from the travaux, had made it absolutely clear that the USSR took the view that in case of espionage, and as an exception, there was no obligation to provide consular access which would otherwise be available. This was with reference to the language of without delay, subsequently undue delay. And he was calling for that language to be deleted, with emphasis being placed upon this particular issue. And what was the response of the chairman? A statement of general principle could not possibly cover all conceivable cases. If the Commission went into the question of whether cases of espionage should be made an express exception, the whole principle of consular protection and communication with nationals would have to be reopened. Now, India reads this as it reads anything in the English language in a somewhat topsy-turvy manner, but what does it mean? 3 propositions. The USSR, in plain and simple language, is making it clear at this juncture, espionage was a special case outside the general approach to questions of consular access. And second, the chairman agreed by stating that the general principle could not cover all conceivable cases, far from India's exhaustive rubric. There's a lot of flowery language in India's pleadings, but there's not much by way of substance. And further, the only way to read the chairman's comments is as follows. Any attempt to open up the espionage exception so as to include express language would throw the entire process of formulating the draft convention into disarray. How else do we read this? If the Commission went into the question of whether cases of espionage should be made an express exception, the whole principle of consular protection and communication with nationals would have to be reopened. He's not saying, don't be silly, there is no such an exception. He's saying, let's not touch that, shall we? Because if we do, we're not going to get anywhere. Of course, that's how I read it from my understanding of English. But if somebody else has got an understanding of English which is intelligible, logical, then I welcome them to explain otherwise. And perhaps, to some extent, this is why the preamble of the Vienna Convention on Consular Relations states as follows, affirming that the rules of customary international law continue to govern matters not expressly regulated by the provisions of the present convention. And that's consistent with Grigory Tunkin's observation. That's also consistent with the way in which their major powers were behaving at this material point in time. Now, of course, it's very rare for espionage cases to appear on the public radar, and this is the first time ever the Vienna Convention on Consular Relations is being considered in the context of espionage. 4 examples we have given. The counter memorial and the rejoinder provide authoritative references. We're not talking about references from newspapers in some provincial town somewhere in the middle of nowhere. We're talking about US State Department official documents. We're talking about texts produced by authorities on this era. Mikhail Gorin, USSR national, 1938, despite a bilateral treaty on consular access of 1933 between the USSR and USA, he was only allowed access in the presence of a US naval intelligence officer, Colonel Abel. Many people will recognize him from the Hollywood treatment, Bridge of Spies, a USSR national, 1957, no consular access sought or provided, convicted of espionage activities. Gary Powers, USA national, 1960, no consular access, convicted by the USSR of espionage. 2 and 3 were swapped in Berlin. Mark Kaminsky, USA national, 1960, no consular access, convicted by the USSR of espionage. That state practice such as one's likely to see in an area as shrouded in secrecy, as subject to subterfuge, as this. But what have academics who have reviewed this got to say about it? Professor Lee, the leading authority on consular law on practice in 1961, 2 years before the negotiation was taking place, a frequent exception to the consular right to protect nationals and visit them in prison is in the case of spies. Clear. Even better, Bishwanath Sen, 1965, 2 years after the convention was adopted. India's honorary legal advisor, 1954 to 1964, 10 years. In his textbook, A Diplomat's Handbook of International Law and Practice, no less, says as follows: a frequent exception to the consular rights to protect nationals and visit them in prison is the case of persons who are held on charge of espionage, as evidenced by the practice of states. Of course, customary international law being customary international law, being based upon state practice and an understanding as to obligation, states are free to modify their own practice. India put before the court 2 examples of state practice yesterday, recent state practice, China and the detention of Canadian nationals, but there is an express agreement, detailed agreement between China and Canada on consular access, and Russia also. But we could give the court many other examples, but we haven't littered this court with examples of what's happened subsequently, because what matters is what the understanding was in 1963 so far as customary international law is concerned. That's what matters, because that was preserved. India's main point, which I have to accept has some force if it had any substance, is that if an exception exists as a matter of state practice for consular access in the context of espionage, some states could manufacture an allegation of espionage, so as to deprive an individual of consular access. We only have to look at that proposition to see how nonsensical it is. Why? Well, this is the first case before this court where the Vienna Convention on Consular Relations is being considered since 1963. So it's worked effectively for more than 50 years. There hasn't been abuse. Not a single one of the other 177 states is before this court, unless I'm missing something, to raise an argument against the proposition that I'm advancing, which they could. None of the permanent members of the Security Council is present before this court to take issue with the observation that I'm advancing. Why? Because they have to maintain, understandably, a position of studied ambiguity. So we have to thank India, in its infinite wisdom, for wanting to help clarify the law as to espionage. We have to thank India for placing these issues before the court as to consequences of illegal conduct, the proper interpretation of the Vienna Convention. And we're grateful to India because the legal community needs clarity. But allegations of espionage are extremely rare. And in this case, the notion that this is an allegation, it's not. It's proven. Commander Jadhav's confession is highly credible. It's corroborated by, at the very least, those 3 independent Indian, highly respected journalists and their investigations. The position of India, in stark contrast, is to disavow through language which is hollow, concoction, propaganda, litany of false allegations. And the passport, we mustn't forget the passport. What is India's explanation for this passport? The expert is a purported expert, a gentleman who trained the Indian authorities for 3 years, who was one of the foremost authorities in the United Kingdom until 2017 on travel document fraud detection, is a purported expert. What a ridiculous suggestion. And then, last but by no means least, the optional protocol, which India sought not to engage, through Articles 2 and 3, allows for what I would describe as multi-tiered dispute resolution. And anybody who drafts commercial contracts or has to engage with them will know that those who seek to avoid disputes will try negotiation, mediation, arbitration, and then eventually go to court. Articles 2 and 3, the discussion is illuminating because these were the subject of discussion by no less than the Indian delegate, as you will see from our rejoinder and counter memorial. And the Indian delegate was at pains to point out that states ought to be encouraged to resolve their disputes through dispute resolution mechanisms. But what did India do in this case? When was the first time India actually sought formally to notify a dispute? 8th of May 2017. Did India, before that, on its case, when it was entitled to consular access, on its case, on the 25th of March 2016, notify a dispute? No. Did India suggest negotiation, mediation, arbitration? No. What did India do? India came to this court on the 8th of May, demanded provisional measures without a hearing, ambushed Pakistan, perhaps in the hope that Pakistan wouldn't appear. Well, it did. And understandably, this court granted provisional measures, perfectly understandably. And much as India wants to scrape the barrel of the internet and try and find one of those who no doubt still believes that the earth is flat to provide some justification to criticize Pakistan, a population of 220 million, there is no official statement from anybody in Pakistan which is other than respectful of this court. So why, oh why, India, from 25th of March 2016, didn't you notify Pakistan of a dispute? Why come to this court for provisional measures without a hearing and tell the court that premeditated murder was about to take place, which is the language that you used, and a hearing was not necessary? When, even now, Commander Jadhav, that video of late November 2018, which you viewed, shows that he's in very good health. And you also knew, India, with respect, about the existence of the 2008 agreement. Because on the 21st of March 2017, before judgment was pronounced on the 10th of April by the military court trying Commander Jadhav for espionage, you were reminded that your request for consular access would be considered in the light of your response to the request for assistance in the investigation process and early dispensation of justice. Not sham trial, not premeditated murder, not lynch mob, execution or death sentence within 3 days, early dispensation of justice to be afforded to a man who was given a 3-week adjournment to prepare his case on the 21st of September in a situation where there were 4 stages of trial. What's Pakistan asking India to do? Reasonably, in an obligatory manner, assist. And what does India say? They note the willingness of the Pakistan side to provide consular access. This is 31st of March 2017. It's in the bundle. What else happens? Never mind the sophistry and the contortions that my friends are engaged in. By now, we're all too used to it. On the 13th of April 2017, the official spokesperson for the Indian Ministry of External Affairs said this: both India and Pakistan also have an agreement on consular access bilaterally. So we're not merely speaking about an international practice. We're speaking here of a bilateral agreement. Suddenly that's vanished when it comes to this court. It can't any longer. And what is that agreement? Article 6 of the agreement could be simpler, could be clearer. My friend pointed to Article 31 of the Vienna Convention on the Law of Treaties yesterday, but all of a sudden, he doesn't want to accept the plain and ordinary meaning of this provision. He doesn't want to accept that it must be interpreted in good faith, in the light of its object and purpose, within its context, namely, as its title suggests, to address consular access. In case of arrest, detention, or sentence made on political or security grounds, each side may examine the case on the merits. And what's the argument? Oh, the merits, that's problematic. Political or security grounds, that's problematic. More than 35 years after this language was used, India's language, because India was pivotal in the drafting exercise, the conclusion of this treaty, India is now saying it's terribly difficult to understand the language national security. It's terribly difficult to understand the language the merits. This is at best being respectful and delicate to India, highly disingenuous, and as far removed from a good faith requirement as could be. And then India says, but the 2008 agreement was meant to deal with nomads and fishermen, of which there are apparently many people crossing because of the border that is 1,000 miles plus, which again raises this bizarre question that I'd raised on the 15th of May. Why choose somebody sitting in Chabahar in Iran, 9 hours drive from Pakistan, to kidnap, to drag him into Pakistan, to force him to give a confession? Why choose somebody of that nature? You've got so many people on the border. If you want to create a fictitious story, why go for him? Article 6 means what it says. Moving on to the next part. India's claim for at least acquittal, release and return is outlandish. By which I mean it occupies a different legal universe. Because this legal universe, in fact, this very room has adjudicated on this question not once but twice, in the Legrand case and the Avena case. But what this court is being invited to do now, I assume because it's Pakistan, and because it seems, sadly, that the present incarnation of India cannot view Pakistan save through a warped, closed-minded perspective, it's being told that, in this case, make an exception for Pakistan. Well, the rule of law applies to all. And as the Attorney General has pointed out, Pakistan's before this court because it's supremely confident in the ability of this court, the world's highest court, the court that upholds international law, that declares international law where necessary, to ensure that international law is upheld. And India, unfortunately, couldn't help itself in its shameless misrepresentation of the experts. India, I'm afraid, can't extricate itself from, at the very least, the credibility, if not the powerful veracity of the confession of Commander Jadhav. India can say as much as it likes about premeditated murder. It no doubt looks good on social media, which is no doubt ablaze at the moment, which is fine. But to talk about premeditated murder in respect of an individual who confessed before a judicial magistrate with stringent safeguards in the context of a trial for espionage that took place over 4 stages over a period of 6 months, allowing him 3 weeks for an adjournment, is a little unfair. Let's be charitable to India. A little unfair to call that premeditated murder. Some might suggest that saying that rapists ought to be hung, if not sentenced to death within 3 days, is a little bit unfair. But we'll leave that to Mr. Modi to explain. India simply fails to answer serious questions which could be exculpatory. But more likely, and that's the explanation why India won't answer them, are damning and implicatory. India invokes 10 reports of the UN Human Rights Committee concerned with the alleged violations of the ICCPR. Not only is this irrelevant, but not a single one of those reports concerns Pakistan. India quotes from reports of an NGO, the International Commission of Jurists. And in case my friend hasn't seen it, there's a recent report of January 2019, which refers to the recent case from the Peshawar High Court, where more than 70 convictions and death sentences rendered by military courts were annulled by the High Court. But the International Commission of Jurists' observations of 2016 and 2017 were premised on the misunderstanding that the High Court and Supreme Court of Pakistan couldn't undertake a review of the military court decisions, which is plainly wrong. The experts said it, and their position was confirmed subsequently by the Peshawar High Court overturning those convictions. And then, in a flourish of enthusiasm, no less than the decisions of the Inter-American Commission on Human Rights are invoked by my learned friend. Now, I could understand why they were invoked as against the United States of America in the Beard, Paraguay, in the Legrand, Germany, and in the Havana, Mexico cases. What are they doing here? But even worse than that, the quotation that my friend puts before the court is incomplete. Now, as a member of the English bar, I know only too well that what I ought to do is to ensure that the court isn't inadvertently misled. I'm not suggesting my friend was doing that, but it might have been helpful to also put before the court paragraphs 104 and 105, because what my friend was contending for was some process which I've yet to understand, whereby there's some sort of cross-fertilization, he puts it. And what he says is that the ICHR decisions of the Commission, which are recommendations, ought to be given weight before this court. But what did the court do, the Commission do in that case, where the Commission was concerned with individuals who were also featuring in the Havana dispute before this court? The court was asked whether or not the individual applications before it were precluded because those individuals were also featured in the ICJ case. Well, the answer of the Commission was the individuals weren't appearing before this court qua individuals. They didn't have locus. And also the Commission went on to say as follows: the central issue before the ICJ was whether the United States violated its international obligations to Mexico under Articles 5 and 36 of the Vienna Convention, based upon the procedures of the arrest, detention, conviction and sentencing of 54 nationals on death row. The issue before this Commission, on the other hand, is whether the United States violated the individual's rights to due process and fair trial under Articles 18 and 26 of the American Declaration, based upon the alleged Article VCCR breach, Article 36 VCCR breach. In the Commission's view, the claims brought before the Commission raise substantive issues that are distinct from those decided upon by the ICJ. Moreover, paragraph 105, the function of the ICJ, and I ask for forgiveness for saying this to the court knows full well what its function is, but I may as well refer the court to this provision, given that my friend didn't. The function of the ICJ, as defined through Article 1 of the optional protocol to the VCCR, is to settle as between states disputes arising out of the interpretation and application of the VCCR. The ICHR, on the other hand, is the principal human rights organ of the OAS, charged with promoting the observance and protection of human rights in the Americas, which includes determining the international responsibility of states for alleged violations of fundamental rights of persons. Even in that case, as can be seen from the decision, despite the fact that two of the applicants had been executed prior to the IACHR's determination, in the Medellin case, a retrial was recommended, even in that situation. Nevertheless, as I said, India's position rests upon this wonderful image that I have of cross-pollination of jurisprudence, of rights recognized across treaties and judgments of these institutions. Let's forget about jurisdictional distinct and separateness. Let's forget about treaty arrangements. Let's enjoin the world to cross-pollinate. And then, India's arguments as to minimum due process, the Vienna Convention on Consular Relations, having the character of a human right, annulment of conviction and sentence being the only effective reparations, have been ventilated repeatedly. This is where the abuse comes in. There comes a point in time where to come before a judicial institution to ask for relief that the court has stated repeatedly is not available becomes abusive. I appreciate there are those who wish to to push the metaphorical jurisprudential envelope. And I'm sure there are many members of the bench who are anxious to do so, but within limits. Because judicial activism, with respect, has to take place within the appropriate context. And the context here, as the court made clear, all too clear, in the Avena case, is as follows. Paragraphs 119 to 124, which I'm afraid my learned friend failed to draw to the court's attention, so I do it now. In the Legrand case, the court made a general statement on the principle involved as follows. The court considered in this respect that if the United States, notwithstanding its commitment to ensure implementation of the specific measures adopted in performance of its obligations under Article 6(1)(b), pausing there, the USA promised to make sure consular access was provided in the future, as the court is all too aware. Since the Avena decision of 2004, there was a UN General Assembly resolution of last year, which was less than complimentary of the position of the United States of America. I say no more, save to refer to the fact that both India and Pakistan were parties to that resolution. However, should the USA fail in its obligation of consular notification to the detriment of German nationals in the future, an apology would not suffice. Sorry, we executed somebody, we won't do it again, which is what happened in the Legrand case. Provisional measures ordered on the 2nd of March 2009, execution on the 3rd of March 1999. In the case of such a conviction or sentence, it will be incumbent upon the United States to allow the review and reconsideration of the conviction and sentence by taking account of the violation of the rights set forth in the Convention. This obligation can be carried out in various ways. The choice of means must be left to the United States. The choice of means must be left to Pakistan, not to India. The internationally wrongful acts committed by the United States were the failure of its competent authorities. Assuming there was such a failure, and I say there wasn't, but even assuming, giving India the benefit of the doubt, which it's not entitled to, in the face of clear, overwhelming evidence of its contumelious conduct, assuming there were failures to inform, as aforesaid, and the Convention was engaged, the remedy to make good these violations should consist in an obligation on, we say, Pakistan, to permit review and reconsideration by the courts of Pakistan. Because if it's good enough for the United States, why isn't it good enough for Pakistan? Does India want Pakistan to be treated differently? Why? Isn't it a member of the United Nations? Isn't it subject to the rule of law in the same way that India is? So the court reaffirms that the case before it concerns Article 36 of the Vienna Convention and not the correctness as such of any conviction or sentencing. The question of whether the violations are to be regarded, assuming there was a violation of the requirement to provide consular access, as having, in the causal sequence of events, ultimately led to convictions and severe penalties, is an integral part of criminal proceedings before the courts of the United States, the courts of Pakistan, and it's for them to determine in the process of review and reconsideration. In so doing, it's for the courts of the United States, Pakistan, to examine the facts, and in particular the prejudice and its causes, taking account of the violations of the rights set forth in the Convention. Paragraph 123. It is not to be presumed, as Mexico/India asserts, despite this judgment, that partial or total, India isn't going for partial, total annulment, and India is not just going for annulment. It wants him to be sent back to India, and wonders why. Terrorism. Is India afraid that the legal processes of Pakistan have yet to be engaged so far as its terrorist activities are concerned? Has India got something to hide once that comes out into the public domain? I can understand why India would want him back as soon as possible. Partial, but that would be wrong. Partial or total annulment of conviction or sentence provides the necessary and so remedy. That assertion is wrong because it's not the convictions and sentences which are regarded as a violation of international law, but the breaches of treaty obligations which preceded them. And then we move on to the Article 36 is in the nature of a human rights argument. Well, that's been gone through before, believe it or not, Mr. Salve. Article 124 says, Mexico has further contended that the right to consular notification and consular communication under the Vienna Convention is a fundamental human right that constitutes part of due process in criminal proceedings. and should be guaranteed in the territory of each of the contracting parties to the Vienna Convention. It's almost as if that's been cut and pasted into India's submissions, which we were treated to a repetition of yesterday. According to Mexico, this right as such is so fundamental that its infringement would ipso facto produce the effect of violating the entire process of the criminal proceedings conducted in violation of this fundamental right. Sounds very familiar. Whether or not the Vienna Convention rights are human rights is not a matter that this court need decide. Quite right. But, importantly, this court would, however, observe that neither the text nor the object and purpose of the Convention, nor any indication of the travaux support the conclusion that Mexico/India draws from its contentions in that regard. Effective review and reconsideration, and I have to refer to the proposition simply to illustrate how absurd it is. India's reply, paragraph 157, makes the bold assertion as follows. Pakistan does not have an appellate procedure by which a trained independent judge dispassionately review the findings of a military court. In the absence of an independent procedure of trial or review of the evidence de novo by an independent appellate court, India claims that the relief should be granted as has been sought in the memorial. Offensive, patronizing, false, contradicted by the experts' reports, and contradicted by the decisions of the Pakistani courts themselves. As recently as the 18th of October, the High Court of Peshawar set aside more than 70 convictions and sentences handed down by military courts. That court didn't shirk from demonstrating appellate procedure. That court didn't shirk from showing dispassionate review. That court had no fear of being independent. It set aside more than 70 convictions and sentences. It didn't hesitate to identify flaws in the processes and evidence leading to the convictions and sentences. The decision is in the public domain. It's a detailed decision, and I'm disappointed that my learned friend didn't have access to it. The Indian team is perfectly capable of finding scraps, slender scraps, of information to suggest there's institutional bias and hostility towards Mr. Jadhav, and a rather laughable reference, which keeps on repeating itself, is to the Lahore High Court Bar Association and the Secretary of the Lahore High Court Bar Association, having said he would condemn any lawyer who acted for Jadhav. What is the Lahore High Court Bar Association? Is it an organ of the state? And who is this individual? Is he one of those who, with respect to him, still believes that the earth is flat? Well, you found your flat earther because the rest of the world in Pakistan was there for you to investigate. No one else said that. But why didn't you find this decision and put it before the court? There's a reason why. Because upon proper examination, what's the court said? The court has been absolutely clear that it will exercise review jurisdiction if there's insufficient evidence, if there's no evidence, if there's absence of jurisdiction, if there's malice of facts and law. All of the underlying convictions and sentences were set aside for insufficiency of evidence. Orders were granted for release. The matter is subject to appeal. Concluding observations. I'm reminded that, of course, the supervisory body in Pakistan is no different from my supervisory body, the Bar Council of England and Wales. It's the Pakistan Bar Council that has disciplinary function, not the Lahore High Court Bar Association. But it shows you how desperate India is, that its reference for institutional bias it finds in the utterance, which isn't accepted in any event, of an individual who occupies the modest role of a secretary of a provincial bar association. Now that tells you a lot with respect. Concluding observations, Mr. President. Thank you for your indulgence in wanting me, in providing me with the opportunity to go a little over 1 o'clock, but I doubt I will. I have 9 points to make by way of conclusion. And again, I make them in the light of the observations I made right at the outset. The court has my detailed written submissions. The court has this document before it in the judge's bundle with the references. And I say, unhesitatingly, based upon the evidence, as follows. First, India's application should be declared inadmissible. I appreciate this is the first time this is going to happen, but sadly there's a first for everything. But we have to thank India for that, because India is the first state to come before this court to abandon studied ambiguity and, in its breathtaking arrogance, to try to continue to persuade the court that the evidence that is before the court is concocted. It's a litany of false allegations. Well, it isn't. And it's not good enough to keep on invoking the same mantra of concoction, irrelevance, propaganda. The burden of proof shifted to India. That burden has not been discharged. As a consequence, the evidence before the court, sadly, manifests abuse of rights, lack of good faith, illegality, lack of clean hands, and misrepresentation. Any one of those would militate against relief. All of them together, not least those brazen attempts during the course of these proceedings to doctor the military experts' reports, to engage in linguistic contortions so as to wish away the 2008 agreement, and this ridiculous document, headed secret, 7-page memo, which couldn't possibly have been created on the 26th of December, all to try and persuade this court of the position of India, taken together, requires this court, with respect, to declare the application inadmissible, or militates against the grant of any relief. Third, the Vienna Convention on Consular Relations is not engaged, as India has not established, for its own reasons, that Commander Jadhav is an Indian national, nor was consular access refused prior to commencement of these proceedings. Customary international law provided for an exception to consular access in the case of an individual reasonably suspected of espionage, not suspected on the basis of manufactured evidence. This remained unaffected by the VCCR. Fifth point, even if the VCCR was engaged, India's conduct in sending Commander Jadhav to engage in acts of espionage cannot but constitute a brazen, blatant violation of Article 5A, a violation of international law, as well as Article 55, non-interference in internal relations of a state. The absurd proposition that's being advanced is officials who have diplomatic immunity ought to be able to go and see Commander Jadhav, to glean from him which of their assets, their tools of terror are still safe, and be able to continue with impunity until they're declared persona non grata. That isn't what the Vienna Convention was intended for, as Grigory, Tunkin, and others pointed out in 1960. And to allow that to happen in this case would provide a fundamental obstacle to the pursuit of the objective of the Vienna Convention on Consular Relations, namely the promotion of friendly relations between states. A red line exists, and that red line has to be shown in clear and simple terms. Sixth point, further in the alternative, India and Pakistan entered into a clearly worded agreement on consular access, operative in material terms since 1982, and amended in 2008, which identified the basis upon which consular access would be considered in the case of an individual reasonably suspected of espionage. The said agreement, at Article 6, must be given legal effect in accordance with its plain and ordinary meaning. And objective. It's not suggested that India and Pakistan haven't applied the agreement for decades. And I respectfully submit it's perfectly consistent with the VCCR, either because it amplifies the terms between the two states, or because it elaborates how they will deal with espionage cases in the context of the absence of any customary international law requirement to provide consular access in such cases. Seventh point, India's claim, which it continues to persist in, for at least, goodness knows what more they want, beyond acquittal, release, return, annulment of the conviction, is being charitable to India yet again, misconceived, being more realistic, at worst, made in bad faith, in the light of the court's previous decisions consistently rejecting such a claim. And there's a reason why, and I'll come to it with my final point. Because India has made no other claim for relief. And therefore, if its all or nothing strategy fails, it should not be entitled to relief. Penultimately, even if the court were to hold that the Vienna Convention on Consular Relations, Article 36 engaged, and a right to consular access was denied, the appropriate remedy is amply provided for by effective review and reconsideration before the Pakistani High Court, in accordance with Article 199 of the Constitution of Pakistan. This remedy has been available to Commander Jadhav and his family at all material times since his conviction. And that is an important point, because India has studiously avoided invoking this. India, Commander Jadhav's family, have not invoked this. It was open to them to do so after the 10th of April 2017. Why not? And I come back to the point that I made before this court on the 15th of May 2017. This case is not about consular access. This case has at all material times, I'm sorry to say, been political theatre, grandstanding, a platform for India to engage in rhetoric. This incarnation of India, I'm sorry to say, not the India that I'm familiar with. And as such, it's an impermissible use of this court. The court can be confident that Commander Jadhav has the entitlement that, even if the Vienna Convention was engaged, would otherwise flow. And it's vital for the rule of law, not least in these times, for the court to review the conduct of India for what it is. And I invite the court to dismiss the application of India accordingly. Thank you, Mr. President.
I thank Mr. Qureshi. Your statement brings to an end today's sitting. Oral argument in the case will resume tomorrow, Wednesday, 20 February 2019 at 3 p.m. for India's second round of pleadings. At the end of that sitting, India will present its final submissions. Pakistan will present its second round of oral argument on Thursday, 20 February 2019 at 4:30 p.m. At the end of that sitting, Pakistan will also present its final submissions. Each party will therefore have a maximum of 1.5 hours to present its arguments for the second round. I would like to recall that in accordance with Article 6, Paragraph 1 of the rules of the Court, the oral statements of the second round are to be as succinct as possible. The purpose of the second round of oral argument is to enable each of the parties to reply to the arguments put forward orally by the opposing party. The second round must therefore not be a repetition of the arguments already set forth by the parties, which moreover are not obliged to use all the time allotted to them. The sitting is now adjourned. Thank you.